as a client, by whom was she referred?
She was referred to me by another attorney, and that is a very common practice in our
Someone
firm.
With ties to Jerry Brown?
Refer to us.
Someone with ties to Jerry Brown or any member of his campaign?
This is just a person who referred her to us, and we never comment on who refers cases to us.
Right, but the allegation is that it's a political smear, that it's a political connection. And so if you would just say that this person is not associated in any way with the Jerry Brown campaign, you could help put that to rest.
Megyn, I've been practicing law for 35 years. I never, ever say who refers cases to us, whether it's an attorney or anyone else. In this case, I'll say it was an attorney, but that's all I'm going to say. I'm not going to change our long-standing policy.
Yeah, but it's not a breach of privilege, and it's not a breach of that person's privacy to say yes or no, they're affiliated with the Jerry Brown campaign. And when you won't rule it out, it adds fuel to the fire that indeed this is a political smear by the Brown campaign, and they're using you and by extension your client as an instrument.
Well, Megyn, anyone who thinks I can be used for any purpose has obviously not watched my career for the last 35 years. By the way, I don't even know, the public should be aware of chapters in my book, Fight Back and Win, where I have criticized Jerry Brown, where in fact the very first news conference I did 35 years ago was where I spoke on behalf of the National Women's Political Caucus and criticized him for not appointing...
What's the matter? You can't answer the question?
That doesn't mean you're not a supporter of his.
Yeah, Allred, keep filibustering her. Answer the damn question, you lying piece of crap.
Donated to his earlier campaign back in 2006. I mean, you're not denying that you support Jerry Brown over Meg Whitman in this race, and that you did even before Nikki Diaz became a client.
In this race, I have not taken a position. I haven't endorsed either candidate, nor have I contributed to either candidate, nor have I...
But you contributed to Jerry Brown in the past.
Of Jerry Brown's, to any member of Jerry Brown's campaign staff, or to...
Allred, simple question. Yes or no? The attorney that referred you is associated with Jerry Brown.
In the past, and you're a well-known Democratic donor, which is why people think you may have a political agenda here. I mean, I'll leave it to the viewers to decide that. I want to talk to you about two things about the case, Gloria, in particular. Now, let's just first talk about the meat of what's actually been filed, which is a complaint for back pay and for mileage with basically the Labor Bureau out there in California. You say she got paid $23 an hour, and that was exploitation. A lot of people out there, knowing the minimum wage in this country is $7.25, say they'd love to be exploited in that manner.
Well, that's not an accurate characterization of what I've said at all. It's completely false. What I have said is that she was required to work 15 hours a week, which she did, at $23 an hour, but that after she was hired, other responsibilities other than housekeeping were also added to her job duties, and that caused her in many cases in many instances to work more than 15 hours a week. But even though she told her employer that she was going to have to work more than 15 hours a week to fulfill all of her added job responsibilities, that she was told that even so, she would only be paid for 15 hours a week. That could be because $23 is a premium, and when you pay a housekeeper $23 an hour, you expect her to go above and beyond the mopping and the sweeping. I want to ask you whether your client ever complained directly to the Whitmans about her salary and asked to be paid more, or asked for mileage, which is the other piece of your actual legal claim. Well, I'm not going to say what she asked for. I will tell you.
Well, did she ever raise it as an issue, which you know is relevant in a legal proceeding? Whether she raised it and gave notice to the employer is relevant.
The employer was aware that she indicated that she could not possibly do all of the job.
But did she object? That's not the same thing as objecting.
In other words, to add to the housekeeping, driving the kids to their friend's
I got you.
house,
I hear what you're saying, but did she object to this?
Other things. Pardon me?
I hear what you're saying, but did she object? She has to raise it with the employer. Did she ever say to Meg Whitman or her husband, not only could I not do it for this salary, but I object because we agreed on $23 a week, an hour for just 15 hours, and I refused to do more?
Well, she didn't say I refused to do more, but she was told. But she was told after she indicated that she was working more than 15 hours a week that she needed to prioritize, and that she was not going to be paid more than 15 hours a week, and that she had to get the job done.
Did she then prioritize to get her responsibilities within 15 hours and then say, this is what I'll do because we agreed on 15 hours, and this is what I won't do because that's the deal?
You know, it's easy for people in your position or my position perhaps to assert that kind of power. A housekeeper who really needs her job is generally not going to say no to her employer because she doesn't want to be fired. So
it's just tough. It's tough for employers, though, Gloria, as you know, to be clairvoyant, you know, and to just sort of discern from the ether that this is going to turn out being an objectionable thing to the employee and wind up in a legal claim. I want to move on to the second part of what we saw.
I agree with that. Nobody should have to be clairvoyant. On the other hand, she did indicate that she needed to work more hours to take care of all.
I know, you just said that. I only have limited time, so I don't want to double back over ground we covered.
No,
and here's the second thing. The other thing that we watched last night, I want to move on to this next point because it's important. The other thing we saw last week was you with the big letter that came from the Social Security Administration to the Whitman family addressing the fact that there was a problem with the paperwork, and then Meg Whitman's husband handwritten notation on it that said, Nikki, please look into this. You later came out and said, so you unveiled the claim that she had mistreated the maid. And then Meg Whitman came out and said, I don't know anything about that letter. We didn't get that letter. And then you waited until then to come out with the letter. So it looked a little like a political sandbag. Why didn't you just bring that letter out the first time and say, they got this letter? You waited for
what a stupid smile on her face.
You have a political agenda, and we're setting her up, Gloria.
Well, I actually thought that I was being extra nice in the first news conference when I was asked for evidence about the letter, that I gave actually some notice to Meg Whitman by saying the specific date of the letter, and also telling the press, who probably went back and told Meg Whitman that if she denied it, then I would produce the evidence, which I did. I don't usually do that. You had the letter with advance notice to people.
You know, we saw the letter, and it's an interesting part of the case, but legally, what relevance does it have? Because I want to ask you this. You know, the letter doesn't say you've got an illegal working in your house. It says, you know, there's not a match on the documents, and the reason for that is because your client lied to the government. She used her sister's driver's license and her sister's social security card, and she lied under penalty of perjury. She lied under oath to the government about her legal status. So there was a red flag raised, and they asked Meg Whitman to follow up on it. But Gloria, as you know, legally, she had no obligation to follow up on that letter. And if she had questioned her maid, Nikki Diaz, about her legal status after Nikki had provided her with a driver's license and a social security number and asserted under the penalty of perjuries that she was in this country legally, Meg Whitman could have been subject to a discrimination violation.
Well, I totally disagree with you.
No, that's a fact. There's no disagreeing with that. Well, that is a fact. That's a factual statement of the law.
Okay. Well, so may I just complete my sentence?
Sure.
Please? I totally disagree with you, Megyn, that Meg Whitman and Dr. Harsh had no obligation to do anything once they received that letter.
Okay, let me just quote. Let me quote Jenny Leo. Let me quote Jenny Leo, and then I will let you respond. I promise. I'm going to give you the floor. I swear I'm going to give you the floor, but I just want our viewers to know where I'm getting this from. Jenny Leo, a labor and employment attorney at the National Immigration Law Center in LA, which defends immigrants in these cases. Quote, this is in the San Francisco Chronicle. There is no additional legal obligation for an employer to follow up or respond to the Social Security information or the Social Security Administration with new information. And then more from the American Immigration Lawyers Association in Washington. Quote, not only is accepting the documents that the illegal would then provide all the law required her to do, but there is a counterbalancing anti-discrimination law that keeps her, meaning Whitman, from probing further or demanding different documents. You go.
The answer is very simple. Anyone who looks at the letter will see what the government instructs the employer to whom that letter is sent to do. And number 5 says that the employer must fill it out and return it to the government, to Social Security. That was not done. Obviously, it wasn't done by Dr. Harsh or Meg Whitman because they denied ever receiving it. So they did not follow the very, very clear instructions on the letter. I don't care what anybody else's legal opinion is. All you have to do is read the letter.
But the letter has nothing to do with your legal case.
What the employer has to do.
The letter has nothing to do with your legal case is about her being underpaid and not getting past mileage. So your focus on this letter, which these other legal experts say does not in any way indict what Meg Whitman did,